All persons having anything to do before the Honorable Justices of the Supreme Judicial Court, sitting in the law court at Bedford, within and for the state of Maine, may come forth and declare, and they shall be heard.
You may be seated. And the matter before the court is State of Maine versus Aaron Robshaw, or Robshaw, I'm not sure which. Penobscot 24-432. We are being streamed on the web both by audio and by video. And if counsel would identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
James Mason on behalf of Aaron Robshaw.
Mark Rucci for the appellee, State of Maine.
Thank you. And Attorney Mason, if you are ready, we'd be happy to hear your arguments.
Thank you, and may it please the court. There are three issues that we are raising on appeal here. First is a sentencing issue, in that we believe that the trial court misapplied the 20-year starting point that's baked into 17A 253A-2. That requires the court, in a case like this, to start its determination, to determine the proper starting point, and that starting point being no lower in the basic step than 20 years.
But didn't I know the green light is on, didn't the justice that was sentencing specifically note that he can go lower than 20 years?
So, yes, there was some discussion about where it is appropriate to go below 20 years. And I think what he was saying was basically confined, and when you look at the second step analysis. Now,
But isn't that correct under the language of the statute? In other words, the 20 years is your start as a base sentence. It must be, you could go up, but you can go below 20 at the second step of the analysis.
yes, you can go below 20 at the second step, but what I believe that a court's responsibility is to properly set the first step, which is the basic step. And I think this court has, throughout its years, used a sort of a continuum analysis. It even says that all sentencing happens on a continuum. And so when you are setting that first step, there is a continuum, but what the legislature has basically said is if this was the continuum here, there's a hard line. But that doesn't mean you can't have a sentence below. You can't.
It doesn't, but isn't that, are you arguing that the statute is unconstitutional?
No, I apologize. That's not really what I'm arguing. I'm saying that the court can determine that this sentence, absent this 20-year, a basic sentence could be, and I'll pick a number, 15, and say, if I had full discretion, I would say this basic sentence would start at 15 years here.
But that wasn't the case here. The court actually did look at it, the situation here, and say, yeah, there's 20 years here, but looking at the unique nature and seriousness of the offense, yeah, 20 fits. I'm good with that.
I think what you're taking is sort of the court's entire analysis of these two steps. And what I'm saying is that the court should consider the court may consider something like this on either the first or second step by not considering it at the first step. And I am not saying that you can set the basic sentence at below 20 years. I understand by statute you can't do that.
That was going to be my question. Are you saying that the court could end up with a basic sentence of less than 20 years?
No, because again, that discretion has been taken away from judges by the legislature. But that doesn't mean that absent that discretion, the basic sentence would have been 20 years. But essentially, what the legislature has taken is 0 to 20 and has said, if you make a determination that it is at that level, you have to move it up to 20.
But that's
which is
true
different than just saying it starts at 20.
That's true with any mandatory sentence. Courts generally are not thrilled about mandatory sentences.
Or defense attorneys are either.
And but there they are. So the legislature said, as a matter of policy, if you violate this law against, faupery, it's got to be a minimum of 2 years. They've set that as a matter of principle. We've already said in Parker, yep, it's constitutional, you can do that. And just as a matter of, but thinking out loud here, the offense here is someone who commits a sexual act with a child under the age of 12.
Right.
And the legislature said, that is so heinous that you've got to start at least at 20, although there is some flexibility to bump it. So that's the scenario. What would you have us do with that?
I don't want to belabor it, I'm just saying, but the word in that statute in 253A is determining. And the court still has an obligation to determine. And determining is not just, well, you get to determine if it's really bad, and you're going to set it above our 20 years, but you don't get to do any sort of determination if it's below 20.
The step one analysis is to rank the crime as it was committed on the spectrum of all the possible ways
Right.
that particular crime could be committed,
Right.
right? Hasn't the legislature determined that if someone commits a violation of Section 253 involving a victim under age 12, there is no way to commit that crime that merits a basic sentence of less than 20 years? Isn't that what the legislature has decided, is that effectively?
I think in the end, but not in the course to get there. I feel as if you have this, you have this spectrum, and the court, in its discretion, determines that it's below the 20 years, you can't do it. But I think the court should say, but I would determine, but for this, but the legislature has told me that if I find it in a situation below 20 years, I then have to move it up to 20.
But didn't the trial court sort of do essentially that? Even if we were to accept that premise, I think the court said something about, based on the quality of the offense itself, did the sentence go upward or downward?
And I think, and that's sort of getting to the second part of my argument, is that that's essentially a step 2 analysis, that we're looking at a mitigating or aggravating factor. And I would say that a trial court can look at this on either, because you have said that, a factor can be used on either step if it's used for different purposes. And the court, I think, does do some assessment of saying, well, that yes, this is sort of in the step 2 analysis, but I think what has happened is it has begun unnecessarily rooted in saying, well, I have to start from 20.
Didn't the court do more than that? The court actually says, I'm satisfied that this is adequate to express how bad this offense is, or was. I mean, the court's done that assessment and says that the 20 years is appropriate in the circumstances of this case.
And I think the language that I saw is that it says, I'm satisfied that in setting such a high minimum, the legislature intended to, and it's the worst ways to commit the offense, but to capture that's kind of lower stratum, it's how it can be contained. And so I think there is some assessment by the court in sort of a step 2 analysis, but I don't think it's sufficiently unrooted from the 20-year starting point, which the court took. Again, and there's a difference between what would be the basic sentence and what it is required to set it once it's set that lower end of it.
So are you saying, based on the language of the statute, I mean, I asked you if you were arguing if the statute's unconstitutional, and you said no.
That's correct.
Are you saying that the word determining means that you get to sort of, at step 1, ignore the language, that it's a basic?
No, I don't think that's...
I'm really confused about what your statutory analysis is.
Yeah, I'm not saying you get to ignore it, but I'm saying that you could say that a sentencing court could say, this is and again, I'll use that same 15 years. And if I had the full discretion, which I don't, I would set it at 15 years. But I don't have it, so then I will take that 15-year sentence is bumped up to 20.
And then what do we do? So what? What if a judge thought that really was too heavy and expressed that on the record? What do we do with that?
Well, I
The
think...
legislature has said that this is what it is. I mean, could they set a mandatory minimum of 20 years?
Well, they could, but they didn't.
I understand, but if they can, what's wrong with saying we're going to start at 20?
Because you're still having the court engage in an analysis of where things fall on the continuum, and then looking at the mitigating and aggravating factors. And if by taking that entire lower portion of the possibility of sentencing off and saying, those don't exist. The possibility of that doesn't exist. You have to start at 20. Then you start getting into the mindset that at trial, the state was saying is that it's always 20 and then it can go up.
Can I take you, in the time you have left, just take you to the supervised release issue? You contended that the trial court failed to conduct a sufficient analysis to support its decision for the 20-year period.
Right.
And as you know, with this offense, probation split sentences aren't available. The legislature has the supervised release approach. But looking at what the trial court said, the term of supervised release will include all the terms proposed by the state. And the reason for this, Mr. Robshaw, is I don't know how else to keep the people safe from you. Then he listed a bunch of things that he had done in the past. He had a first sex offense, he didn't reform, didn't comply with registrations, you hurt the girl, hurt the family, hurt us. And I don't know how to prevent that from happening again other than put you under supervision for a long time. So isn't that the analysis that floats the boat for supervised release? What's wrong with that?
I would say that it doesn't go far enough. In this court's decision in Cook, there was a listing of things that you need to consider. And I acknowledge that the decision also said you don't have to do the full sentencing analysis when you're looking to it, but there is still an analysis that's needed to be done. And what was essentially offered is just, well, we're going to need to have this time after you get out.
Well, he's saying you didn't get it the first time around, so I need to bump up the level a little bit here.
But there, aside from that one lone factor, essentially, I don't know how we're going to protect the community. There's really no other analysis supporting the fact of not just supervised release. He doesn't have discretion on whether he's going to order supervised release, but he has discretion and how much to order it. And no analysis was given to what that number was going to be. And I think you're looking at essentially imposing potentially a second 20-year sentence. I mean, like, that's what supervised release is. And it's not supposed to be punishment. It is not supposed to be punishment. Your jurisprudence has said that. And so there needs to be some more analysis than just simply, well, we've got to protect the community. And analysis.
But there was a basis for that determination that there was a need to protect the community based upon the history of this particular defendant, was there not?
No, I completely agree with Justice Lawrence. When you have a second offender, a second-time offender, you're going to be able to say, well, you didn't comply beforehand because you're back here now. But I still think you need to have some sort of analysis that sets the years as well. I think both of those things have to happen on why you're going to apply it, even though you have to, and why you're going to apply it in the term that you're going to choose.
How would you do an analysis as between him? He talked about supervised release, that there needed a substantial period based on the prior record and prior failure to register. What should the analysis be to say a 20-year period of supervised release as opposed to 10?
There was some discussion about the age that he would be, even any sort of discussion about the offense, the levels of recidivism at ages, because he just got a 20-year sentence. And is the level of recidivism at all related to age? And I think anything other than, well, we're going to have to do it, I think is the analysis that would have been good.
But can't we draw the inference? I mean, even if the court didn't have, I don't know if they're magic words that you're looking for, but we need to protect the public. I think he's a danger. It's going to be 20 years. Can't we draw the inference that that's why the court picked 20 years, because he felt that amount of time was necessary to protect the public?
You may answer.
Thank you. I think we can't go back. We can't look at the sentence imposed and go back and use it as the justification for why it was imposed in the first place. I think there's got to be something that establishes that the court picked that number itself to support the reasons that he was espousing.
Thank you. Attorney Rucci.
Good morning, and may it please the court. The opening that I had crafted wasn't responsive at all to the questions that you've asked of Attorney Mason. So permit me just to say that from the state's perspective, the mandatory basic, the 20-year basic sentence imposed, I think it's under 253C now, is just one example of the legislature doing something that it often does, which is using its authority to craft sentencing mandatory minimums. This is not a mandatory minimum. It's less restrictive than a mandatory minimum, but to that extent, the legislature often says, in certain classes of cases, including felony classes of cases, if you find a defendant guilty, there is a mandatory minimum sentence. Therefore, usurping this court's ability to conduct a full and free Huey analysis. That doesn't make the statute unconstitutional, which I understand Mr. Mason to be arguing it is not. That doesn't mean that the court must somehow still consider at step one determine the basic sentence somehow free and clear of the legislature's 20-year basic sentence. I think of OAR felony offenses carrying 6 and 9 month and 2-year mandatory minimums. I think of OUI offenses carrying sometimes sometimes 6-month mandatory minimums. I think of violent crimes committed with a firearm carrying 2-year mandatory minimums.
Should counsel assume that the 20-year period is the floor, that that's the least serious way the offense can be committed, and build from there?
Yes.
And elaborate, please.
Well, Your Honor, the legislature has clearly made a determination that at step one of the analysis, the court shall select a term of imprisonment not less than 20 years. That does not mean the court can't go down in considering the step two of the Huey analysis, but it does mean that the legislature is signaling when you commit a violent sexual act against a child who is under 12 years of age, you start the sentencing analysis at 20 years.
But my question is, does that mean that's the least serious way the offense can be committed and you build from there, or could actually the offense in the judge's mind be less serious than that, and I would start building from 15 years?
Sorry, I misunderstood. I certainly argued at sentencing that it was the legislative's prerogative to say this is the least serious. Justice Maloney rejected that and was well within his right to do so. I'm not aware of any of any legislative history that speaks directly on point. He reached the conclusion that the 20-year basic period was designed to catch the lower stratum of the ways in which this crime could be committed.
So it is the floor.
I can't say that that's erroneous, his determination.
So if the judge figured, looking at these circumstances here, if I were to do this in the absence of the 20-year mandatory minimum, I would have pegged this at 8 years. And as it came up here, I'd pass 20 only when I'd get up to a much more serious incarnation. So does that judge have to start at 20 years, assuming that is in fact the least serious way, or can there, I think that's sort of what the defense is saying here, that the judge has to start and assume that that is the least serious. So if it's, I hate trying to quantify these things, but if it's somewhat more serious, it starts to build from 20 and goes up to 22.
I think I'm understanding Your Honor's question. I guess the answer would be if the judge says, boy, if I were free and clear to do this how I wanted, I would have set the sentence at 8 years. Judge can't do that. In the same way that a judge can't say, boy, in this OUI involving serious bodily injury, if I had my druthers, I'd really sentence you only to 3 months, but I have to sentence you to 6.
Let me try one more time. I'm not explaining it very well, but when you look at any offense, there's a continuum. Imagine a graph that starts narrow and gets bigger as it goes on, as it gets more serious. So down here at the 0 point, that's the least serious way. And there's a continuum, and the judge will stop at some point on that graph and say, this is where this case is here. What I'm questioning you is, does that, if this is the 20-year minimum, is this 0 here and the continuum expands going up from there? Or can the judge look at it and say, well, I would have started the continuum back here and it hits up here, so I'm not going to go very much further than that. That probably just complicates it more than I intended, but I'm just trying to figure out where does the judge start in the judge's own mind to create that continuum of seriousness?
I think that, again, I'm not trying to dodge your question. I'm trying to answer it as fully as I can. I think what the judge would have to say is, no matter where I think this subjectively falls, if I were to do that continuum analysis, the basic sentence is 20 years.
Can I ask this? I'm not entirely clear of what the defense's argument is, but I think I heard him say that the basic sentence is prescribed at 20 years. But in step 2, the court can take into consideration other information that may relate to the nature of the offense as long as it's being used for a different purpose in step 2. What's your reaction to that?
Well, I certainly addressed that point in my brief, Your Honor, but my sort of, I'm loath to accept that analysis because you run the risk of violating another statute. We know that Huey has been statutorily codified and says at step 1, you determine the basic sentence, just as Justice Horton said during Attorney Mason's argument. At step 2, you consider the maximum sentence by taking into account the ways in which by taking into account factors specific to the offender. If you now say, well, what the judge has to do is take all these factors from step 1 and move them to step 2, that's in contravention with the statutorily codified Huey analysis, and it also, from the state's perspective, Your Honor, it's what it really would be doing is it would be a judge saying, I'm not going to listen to you, the legislature, and saying that the basic sentence must be at least 20 years. I'm going to consider these factors later and perhaps come to a maximum less than.
Can I ask you about the supervised release analysis? I mean, all he really said is he needs a long period. I mean, don't you have to do more than that to distinguish why 20 as opposed to 25, as opposed to 15, as opposed to 10 years of supervised? I mean, there was no discussion in the analysis. It just basically said, well, he has a prior offense, he failed to register, he needs a long period of supervision. Doesn't it have to be proportional? I mean, he has ended up giving him a sentence that, as far as the legislature was concerned, was at the short end, shall we say.
Mm-hmm. I thought it was, so a couple points to that, Your Honor. One would be, I think it depends on the type of crime that we're talking about. Anytime a court sets a period of supervised release or a period of probation or a period of incarceration, it bears acknowledging that it's not mathematical, that it involves some degree of judicial, sort of skill and ability.
It does, but usually when you explain it in a Huey analysis, if you took away the basic here, you'd be talking about what the circumstances are, where you think it falls on the continuum, what the individual characteristics are, whether that raises or lowers, et cetera. And doesn't there need to be some kind of analysis? I understand it's not magic, but usually when you do a Huey analysis, you have some idea of why a judge lands at 25 as opposed to 5, right?
Sure.
I don't know that we have that with regard to the supervised release here. Do we need that?
I would assert that we have enough, Your Honor, because what we have here, and when I say what type of crime we're talking about matters, is we're talking about obviously a sex offense of a child under 12 committed by someone who the judge noted had a prior sex offense to his record. And he said the paramount interest here is to protect the public from you. If you were able to be reformed, you could have been. I need to give you a serious, significant period of supervised release in order to protect the public, which, given the type of crime that we have and the defendant's history, from the state's perspective, and in accordance with this court's jurisprudence, that not every factor under the sentencing goals not related to punishment needs to be considered. I think that one factor carries the day in this case.
Given this sentence, what's the maximum amount of time that Mr. Robshaw could be incarcerated?
Okay. Your Honor, I always have to pull out my 17A when I reach this, but my understanding is he goes to jail, he serves his 20 years, less good time and less whatever he's entitled to. He gets out. If he violates, he can go back for another 20 years because he's sentenced to 20 years of supervised release.
And then when he finishes that 20 years, does he still have supervised release following that?
I don't believe so,
So
no.
he could serve a maximum of 40 years plus or minus good time.
Effectively, that's my understanding, yes.
So in light of that, shouldn't we expect there to be a more robust analysis in imposing supervised release than what was employed here?
A judge could, put on the record a more robust analysis than was put on the record here. Was he required to? Your Honor, I would posit, and I forget exactly where he said it, so forgive me if this went to his imposition of a 20-year sentence, but the judge said, you know, by the time some time is up, you're going to be of the age where you're less likely to recidivate, and that was one of his goals, was to have this defendant under the thumb for a period of time that would ensure that no other child was victimized by his behavior. And I think that is enough of an analysis, Your Honor. I shouldn't say I think. I argue that that is enough of an analysis, Your Honor. And if there are no further questions,
Don't appear to
I'll
be.
cede the rest of my time. Thank you, everyone.
Thank you.
Mr. Mason?
When I hear multiple judges say, I think counsel's argument is, then I think I should maybe take another shot at this. I think is essentially, what the argument I'm essentially making is that there are two places where you can consider the nature of this crime, whether this is in fact one of the least worst ways, as the trial judge said. In the lower part of the continuum, the 0 to 20, that there are ways that this can be committed 0 to 20. And I believe that that is what this being a starting point and not a mandatory minimum says. That the court
But isn't that exactly what they didn't say? I mean, they said that, no, we don't think there is any way of committing this that warrants less than 20 as a starting point.
I think in using the language determining, that it says that there is still some analysis that goes into this, and it can't just be to make this more severe. There is still range under the 20 years that is part of the continuum. The continuum doesn't start at 20. And I think that should be taken into account. And if it is, the problem of why it should be taken into account, at least in some manner in step one, is because then you will get judges who will say, well, then my sentence starts at 20, I have to set it there, but that means it just sort of goes up. And you will not get in a trial situation.
So you could have a basic sentence lower than 20 years?
No, you should, if, with absent this 20-year starting point, the judge may say, well, this is where I would set it.
But what good does that do?
Because at least it puts the judge into the perspective of saying, I'm still judging this on the continuum, as opposed to saying, well, nothing can be less than 20 years.
Don't you end up at the same place, in which case, not saying that is harmless anyway?
I don't think you do end up the same way, because you don't, if I just may finish
Finish
that.
your answer.
Because when you are then going to step two, you then have to see overwhelming mitigating factors, which in a case involving a victim under 12 that went to trial, it is going to be very unlikely that those will then, post that application, be taken into account.
Thank you. Thank you, counsel. This is our usual practice. We will take the matter under advisement and issue a written decision in due course. Thank you for your argument this morning.
All rise. We are in recess.
morning. You can be seated. The matter before the court is York 24552 regarding the children of Krystal W. We are being streamed both by audio and by video. And if counsel would identify yourselves by saying your names for the record together with the party you represent.
Attorney Brittany Sawyer. I represent the appellants, Melissa and Richard Foran.
AAG Hunter Humphrey for DHHS.
Thank you. And Attorney Sawyer, if you're ready to proceed, we'd be happy to hear your arguments.
Thank you. May it please the court, Chief Justice Stanfill and Associate Justices. I represent Melissa and Richard Foran, who are foster parents and have been foster parents since November of 2019. They have adopted 2 children through the foster care system, as well as been placement to other children, including the children in this case. The children in this case were with the Forans for 19 months before they were abruptly removed from their home in September of 2024. At the time the Forans filed their motion to intervene and a motion for judicial review on placement, the case was in a post-termination status, meaning both parents' rights have already been terminated. The Forans had signed an adoption agreement with the department, and they had been acting as the child's parents essentially for many months, including signing that adoption plan with the department, and the children called them mom and dad. They also saw the other children in the home as their siblings. The department contends that the Forans have other courses of actions in this matter to pursue their concern of placement. They did file an appeal of the substantiations through the administrative process, but that process does not address placement, only the department's findings. And it does not result in a final judgment in this case, as those findings had been overturned. The department also notes in their brief that the Forans could pursue adoption, and they have. But again, that doesn't immediately address the placement concern that can be addressed through a judicial review or an emergency judicial review. Filing this action was their best route to avoid irreparable harm to their family. The department gave this family no opportunity to be maintained and for these children to achieve permanency in a time reasonably calculated to meet their needs. In this action, unlike many of the other cases this court has seen regarding intervention, there's no impeding of other parental rights here, as we're in a post-TPR state, and there's no parents here that have to defend against the intervention. The only parties left at this point are the department and the child and the guardian.
Counsel, I see that the green light is on. Can you clarify whether you are seeking intervention under 24A or 24B? It was unclear to me what you were arguing. 24A meaning intervention of right, and 24B meaning permissive.
I believe it's permissive.
Okay, so if it's permissive, what's the standard of review?
I believe it's an abuse of discretion.
And didn't the judge articulate some reasons, even if somebody else might have decided differently?
There was one motion was denied outright with no reasoning, and the other motion was denied with just a one-line citing to a guardian. However, the guardian in this case had just recently been appointed and did not take any position on our motion. I'm not aware if the guardian had ended up filing anything after that.
Permissive intervention is when you have a claim or defense in the main action, have a question of law or fact in common. What is it? Your folks don't have placement?
They didn't at the point they filed. They had been foster parents and pre-adoptive parents of
Okay.
these children, and that's how
So
they filed.
are you suggesting that any resource parent has a right to intervene or ought to be able to intervene, at least at the post-DPR stage?
Potentially. I think it may be fact-dependent on the case of how long they've had placement and whether or not they've entered into a pre-adoptive agreement with the department.
How does that factor into the factors under Rule 24?
I don't have that rule right in front of me, but
Well, permissive intervention says upon timely application, anyone may be permitted to intervene in an action when an applicant's claim or defense and the main action have a question of law or fact in common.
Well, I believe here, when we were looking at is under Title 22 and the the specific factors in there of when a party can intervene in a child protective
Title
action.
22 says an intervener is someone who is granted intervener status in a child protective proceeding pursuant to Rule 24.
And a foster parent does have a standing in the proceeding while they have placement of the child. They have no other way to proceed to regain that placement other than filing a motion in the court, from our perspective.
So in your mind, counsel, is this an appeal of an order under Title 22?
I believe so, yes.
And if it is, how do you get around Section 4006?
It is our view that this falls into the death knell exception.
Okay, but 4006 says unless it's an order under Section 4035, 4054, or 4071, it's interlocutory and not appealable. And we have said that we can't make exceptions to that.
In the case of In re LR, which followed a case that's very similar to this one that was decided, in which you cited In re NW, but in the subsequent case, within a year or so thereafter, I think this court made it clear that the judicially created exceptions to the final judgment rule, including the death knell exception, have no applicability to orders appealed under Title 22. How do we get around that?
So I think that if we're looking at irreparable harm here for this family, they have no other course of action than to file this appeal and for it to be considered under that.
So what's the exception?
I believe it's the death knell exception.
But In re LR stands for the proposition that none of the exceptions, including the death knell exception to the final judgment rule, apply in appeals of orders issued under Title 22.
Are you saying any of the orders that don't fall into the specific provisions outlined in Title 22 that are appealable?
There's 3 orders that are appealable under Section 4006: a jeopardy order, a TPR order, or a medical treatment order. That's it. Now, I have a different question for Mr. Humphrey when he's up there, but 4006 also goes on to say no other orders are appealable.
The exact language we used in Ray LR is, quote, "To the extent that our prior cases can be read to suggest that the traditional judge-made exceptions to the final judgment rule can be applied to interlocutory appeals in child protective cases, we clarify that absent any constitutional infirmity in the statute, we cannot craft exceptions to Section 4006.
Is there any way that this appeal can be characterized as something other than a Title 22 appeal?
I don't believe so because of the particular factors of the case. I think
Could
would
it
have
be
to
characterized as an appeal because it was decided under Rule 24 and not under Title 22?
Potentially, yes.
And that could arguably take it out of 4006?
Yes, it would.
But Title 22 in Section 4005D specifically brings in Rule 24 as the factors to consider when determining whether an intervention is appropriate, but it doesn't say anything about appeals.
Correct. It's silent on that issue.
So this is still a Title 22 order, isn't it?
It is technically a Title 22 order.
What legal interest are the foreigners protecting here? Your motion or their motion says the petitioners seek intervener status in order to ensure their legal interests are protected. What is their legal interest here?
So I think they have an interest as a parent here. They've been acting as a
A
parent.
legally cognizable interest, or they care? In other words, legal interest, or interest in the sense of they really care a lot?
Well, I don't think that there's a statutory basis yet, although there have been bills drafted and discussed about giving foster parents a legal right as a parent, but at what point, I think we have to look at, when do they become a parent? Yes, they've been giving the care of a parent as a foster parent, but when you've had a child in your home for 19 months and you've signed that pre-adoptive agreement and you're in the process of working with an adoption attorney to adopt these children, you really are a parent. You're acting as a parent to these
But
children.
doesn't that blow it wide open? Any person who ever served as a foster parent has standing, standing is a big deal. And if simply having had temporary placement gives them that status, that's a significant legal development.
It could if there was something stating that any foster parent at any point could. That could potentially blow things open. But I think there's a difference between a foster parent who's had a child for a short amount of time and someone who's had a child or children for 19 months and is in the process of adopting them, and there are no more legal parents to this child.
And
Does
you
the
said
pre-
in the process of adopting, there's nothing preventing them from filing the adoption and proceeding on the adoption. I understand that they may not have the agreement to the department, but that is not the sine qua non. I mean, they can be granted over the department's objection.
They can, yes, and that that action has been filed as well, but it doesn't address the placement issue as quickly as my clients would like to address.
Section 4005D gives foster parents the right to be heard in proceedings. It's not entirely clear what future proceedings are contemplated in this instance, but what does the motion to intervene give your clients that goes beyond the right to be heard? What do they need beyond the right to be heard?
Well, they were looking for a hearing to be set on their motion to address the placement of the child and the opportunity to present evidence at that particular type of hearing.
You would agree, though, that if they had that hearing and the judge ruled against them, that would be the end of the line. That order would not be appealable, right?
That has been my experience, yes.
Is this a frequent occurrence that placement parents will intervene in Title 22 proceedings?
In my own practice,
I understand you practice in this area. I'm just wondering, in your own experience, is this something you have seen in the past?
I have, yes, on many occasions. I believe the light went red, but I'm not sure if.
Yep, so you still got 39 seconds. But I don't see any other questions.
Thank you.
I have the advantage of being able to see the clock. Attorney Humphrey.
Good morning. May it please the court. Child protection proceedings exist so the state can exercise its parens patriae authority to keep children safe. They are closed proceedings. The voluminous records associated with them are confidential. Intervention in a matter this sensitive is not available on demand. By law, it may be granted only to one who shows that their involvement as a full party would further the purposes of the Child Protection Act. The appellants did not. That's why Judge Duddy soundly exercised his discretion in denying their motion. This court asked us to brief another issue as well. Section 4006 of Title 22 provides that just 3 orders are appealable in child protection proceedings: jeopardy orders, termination of parental rights orders, and medical treatment orders. Statutorily, that is the scope of appellate jurisdiction in these matters. As this court explained over 100 years ago in Simpson v. Simpson, 119 Maine 14, our law court is purely a creature of statute, and as such can hear and determine only those matters authorized by statute and brought to it through the statutory course of procedure. We respectfully request that this court reaffirm that long-standing legal principle today. Judge Duddy's order should be affirmed in any event, and I welcome your questions.
Can I take you through the framework on the appealability of the order and make sure that I understand or have all the pieces to consider? The motion to intervene, or intervener status is defined, is a better way to put it, under Section 4005D1D, correct?
Correct.
And it's defined as somebody who's been granted status under Rule 24 of the rules.
So long as intervention is consistent with the purposes.
But the first step is an analysis under 24, correct? I mean,
Yes.
you don't get to the other one if you don't meet those. All right, then we get to the appealability. Our jurisprudence is that ordinarily in other kinds of cases, denials of a motion to intervene would be appealable as an exception to the final judgment rule. Do you agree with that?
Correct.
Okay, so the question is what happens in Title 22 cases, right?
That's right.
And in Ray NW in 2013, although with not a lot of discussion, that was appeal of a denial of motion to intervene in a PC case. And we said an exception to the final judgment rule permits those appeals, correct?
That's correct.
In Ray LR in 2014 was not an appeal of a motion to intervene when we said we cannot create judge-made exceptions to the limited rights of appeal found in 4006, right?
That's right.
But then in Nicholas P. in 2019, we said that is true, but we have recognized that an order entered in the context of a child protection case, but which is not itself an order entered pursuant to the Child and Family Services and Child Protection Act may be cognizable on appeal despite the limitations created by 4006. Is that the issue here, whether a motion, in terms of the appealability, whether a motion to intervene is really an order entered in the context of a child protection case, but which is not itself an order entered pursuant to the Child and Family Services and Protection Act?
I think that's one argument, and I think the gloss that Section 4005D puts on the Rule 24 intervention analysis is the reason this is a child protection order, as I think the appellant agrees, entered under Title 22. We're not only looking at what Rule of Civil Procedure 24 says about whether intervention should be granted. 4005D says we're looking at all of that, and additionally, whether intervention is consistent with the purposes the legislature set out in enacting the Child Protection Act. One of those purposes, Section 4003, Sub 3, is to avoid needless delay in getting children to permanency.
But in Nicholas P., the parentage order, becomes part of many child protective cases have to make a parentage determination. But we said, although made in the context, it still is not a child protection order. How is that different?
It is not dealing with a motion to intervene, and it's dealing with an appeal brought by a parent with a fundamental liberty interest at stake.
I mean, the one case we have dealing with a motion to intervene said it is appealable.
That's true, and we ask for this court to harmonize its jurisprudence advisedly. This is a difficult task in this particular area of the law because I think that the transition from In Re NW in 2013 to the language in Re LR in 2014 appears somewhat abrupt in some senses. And that's why I was hearkening back to the Simpson versus Simpson language from 100 years ago. You look even further back, a full 60 years ago, the stenographer cases, so-called. This is a longstanding principle. This court has described itself as a statutory creature.
So from your perspective, we're listening to the agency, to which we defer in interpretations of statutes if they're ambiguous, and it's your position that this shouldn't be appealable.
Based on the way that this court has described what is or is not appealable.
But it's the agency's interpretation of the statute that we defer to, that you administer. So if we're going to give deference to your interpretation, we need your interpretation. And it's your interpretation of the statute that it's not, if it's not listed there, it's not, this kind of order is not appealable.
Well, I think the deference that we're requesting is for this court to defer to the legislature's statutory grant of appellate jurisdiction. The legislature established this court. It established the child protection framework. In Section 4006, it was very clear about which orders would be appealable.
So in 4006, the very first two words are a party. Resource parents who are not a party to the proceeding may have a different argument. And so in the spirit of taking up your invitation to harmonize this tension, let me ask, are there circumstances which we ought to take into consideration that would involve people who aren't a party to a proceeding, but who should be a party. And if they are denied that opportunity, shouldn't they have a right to an appeal? Because if they're not able to appeal it, they're out. And I'm thinking, you know, maybe this is one case, maybe there's other cases of a situation where you have a couple that has split, they're not married, they've raised the child together, the non-residential parent wants to be involved, has no other way to get involved except to intervene, file a motion to intervene. Shouldn't that person be allowed to intervene?
Any given case could be different on its own fact pattern. I'm limiting my argument today to the facts of this particular case. On this record, Judge Duddy soundly exercised his discretion in denying this motion.
But that's on the merits. I'm talking about the justiciability issue.
Well, and so in the stenographer cases 120 years ago, this court said the legislature has authority to withhold the right of appeal and compel suitors to be content with results reached in the trial courts. Our reading of the case law, the text of the statute, is that that's what the legislature has done here.
And we
This
agree
court-
that this legislature can do that. And they've clearly limited a large portion of what can be appealed under 4006. Isn't the question whether, I mean, that's why I was asking, isn't the analysis really, the issue is whether this is an order under the Child Protection Act, or is it outside of it? Or are you suggesting that In re Child of Nicholas P. is wrong?
I'm not suggesting that today, and I think the way you framed the analysis is certainly helpful. You look at a case like In re Children of Mary J., Passamaquoddy tribe moving to intervene, has the motion denied and appeals. I would posit that the reason that was appealable is because that was not an order analyzing Title 22 or the rules of civil procedure. It was analyzing the Land Claim Settlement
Well, you
Act.
said, or the rules of civil procedure, but why is that not, if it turns on that explicitly, in other words, that Section 4005D1D could have said, here's the standard for intervention in a child protective case, and it doesn't. It says it's governed by Rule 24.
Governed by Rule 24, so long as intervention
I
is consistent
understand,
with
but
the
the first
purposes.
analysis is under Rule 24. Isn't that more like ICWA? I mean, where it's outside?
I don't think so. And ICWA actually did not pertain to Mary J. because the children were not eligible for membership in that tribe.
So if I could come back to the Chief's point and ask this. If we do look at this through the Rule 24 lens, how would a person ever satisfy the permissive intervention standard of Rule 24B? Aren't we really talking about 24A, where you have a right that you're trying to protect, as opposed to the standard under Rule 24B?
Their motion, in fact, quoted the language of 24A, and that was what I had understood them to be invoking. How someone would ever satisfy the provisions of 24B, I don't have a formula for. I think it's going to be a fact-intensive inquiry, and it's going to be analyzed by a judge who's in receipt of all the guardian ad litem reports that were filed throughout the case's long pendency, and will be coming to this motion with a wellspring of information about what's been happening in this family. And I think some of the analysis here about the merits and whether Judge Duddy abused his discretion has to do with whether we regard a motion to intervene as a knock on the door or the use of a crowbar to lift the door off the hinges.
And that's really, is it fair to say that the department's position generally on, well, let me back up, motions to intervene are actually filed relatively frequently in child protective cases, you agree? They're not actually granted, but they're filed.
I wouldn't say frequently. They're not unheard of. In my experience in the trial court level would be Washington County and Somerset County. I did not see them frequently.
Okay.
But, Maine's a diverse state. There's regional variation.
There
On
are
the
places
appellate
where
level-
they are.
Yes, and on the appellate level, I have a view of that, and these are very unusual.
Do you agree that, from the department's point of view, that to the extent motions to intervene are filed in these cases, they should be it should be an unusual situation where they are granted as opposed to denied?
Yes, and that ties into an aspect of the statutory framework we should discuss today. The legislature set up these proceedings with levels of engagement It's not that you're either out or you're in. You can be an interested person with the right to attend court. You can be a participant with the right to be heard. You can be a full intervener with access to discovery, the ability to cross-examine witnesses.
But those statutes give status automatically to somebody who is a foster parent, or resource parent, but in this case, they aren't anymore. So can they get status as a participant or interested person?
Theoretically, far as I know, they didn't ask Judge Duddy for one of those lesser included, if you will, statuses. That's something that could have been done. The other aspect of the statutory framework that's important to consider is the mandatory review period. Section 4038 says that at least once every 6 months, the district court judge is going to need to review the case, do a judicial review. There are factors the statute enumerates about what will be considered there. Placement, suitability and safety of placement is one of those considerations at every review. So we know Judge
Counsel,
Duddy...
before the time runs, it's about to, can I ask you this? Under 4005D6, foster parents, pre-adoptive parents, and relatives must be provided notice and the right to be heard in any proceeding held with respect to the child. Did the Forens have a right at least to be heard here?
When they were foster parents, they did.
So your position is once they were no longer foster parents, but were they still pre-adoptive parents at that point?
No, my understanding of this situation is that for a time they were employed by the department as foster parents. At the time all of this motion litigation was occurring, they were no longer employed as foster parents. This is an important opportunity to consider who these cases were set up for by the legislature. They were set up for parents to have an opportunity to rehabilitate and reunify with their children, legal parents. This is not a case like Child of Philip S., where you had former foster parents asserting that they were de facto parents. This is distinct from that. We're at a critical moment in this state's history where there's been about 40 indigent parent appellants waiting for the appointment of counsel so that their appeals can be heard. Those are the people the legislature set these cases up for. In terms of the larger legal issue before this court today, we're certainly humble about the fact, with some humility, that we're acknowledging a little tension in the case law between NW and LR. It is not for us to tell this court that any of its past decisions were or were not wrongly decided. We're just asking for this court to look closely at some of those much older precedents, Simpson versus Simpson, the stenographer cases, that talk about this court's statutory grant of appellate jurisdiction. And I think it's important not to lose sight of that. Thank you.
Thank you. Attorney Sawyer, you wish to be heard in rebuttal?
I want to clarify one point there that my clients were still licensed foster parents at the time they filed the motion in this case.
But they weren't the foster parents to this child?
They were not the foster parents to these children at that point, but they were a licensed foster home for the department still.
But they could, even if they're not, they can still seek access to proceedings as an interested person, right?
I believe they could. I don't believe they need to hold a license in order to access the proceedings.
No, it says that an interested person is anyone that the court has determined as having a substantial relationship with the child or substantial interest in the child's well-being. It could include teachers, coaches, et cetera.
Absolutely. And I've also seen, and I think the department's objection cites to this, that there can be some limitations made to an intervention when it's granted. I've seen that happen, or I've seen the court grant different status when somebody has filed a motion to intervene. So the trial court does have the ability to limit what information. I don't believe my clients in this case were looking for discovery from way back in the case, back when the parents were involved.
Isn't an intervener a full party as opposed to a participant or an interested person? There's a difference.
There is, and I believe they needed to have intervener status in order to present their evidence to the court for this particular motion they were filing. I also wanted to note that in 4003, I think the purpose of the statute also circles a lot around the children and the health and safety of the children and the right to family integrity. And here, these children were a family with my clients at the time this was filed. And they were on their way to finalizing their family being official in the legal eyes. And in this case, Having a hearing earlier on these motions, I think, would have avoided some of the delay that these children probably are going to have now in permanency by the motions being denied and my clients not being able to be heard. I don't have anything further.
There don't appear to be further questions. Thank you.
Thank you.
Thank you, counsel. As is our usual practice, we will be taking this matter under advisement and issuing a written decision in due course. Thank you.
All rise. We are in recess.